The H-1B registration system for the fiscal year of 2027, which will happen in March of 2026. What is actually changing and what's not changing, and how can you start preparing now? That's what we're talking about on today's Live at Lunch. My name is Emily Sumner with Sumner Immigration Law, and I'm so glad that you're joining us, whether you are joining us live or catching the replay. So again, we're talking about the upcoming changes to the H-1B registration system that will be implemented starting in March of 2026. There are a couple of key things, two big changes that are coming up starting it for this upcoming registration system in March, or registration period in March 2026. The first is the weighted selection process. The second is the possible $100,000 fee. If there's one thing that I want you to take away from this live, I want you to know that the $100,000 fee does not apply to every single H-1B registration or petition for a CAP case. It only applies in certain circumstances. So let's get into it. The first change that is coming, there was a final rule published by the Department of Homeland Security it was published on December 23rd, so day before Christmas Eve, yay. That is the final rule for the weighted selection process. This means that instead of there being a random lottery, like there has been for all of these years, a random lottery for the H-1B selection process or the H-1B CAP registration process, the selection will be based on the prevailing wage level. So the process itself will stay largely the same. To be clear, we do not have a lot of information yet from USCIS about how this is actually going to be implemented. So we have no idea yet what the registration system is going to look like. We have an idea of the general information they'll ask for, but we just don't have details from USCIS yet. Hopefully those are coming soon, and of course we'll share that information with you as soon as we have it. But overall, high level, this regulation that was published in December and will be in effect for March of 2026 is that USCIS will, instead of conducting a random lottery, they will have the selection of the H-1B registrations be based on wage level. So as you may know, for an H-1B petition that is being filed with USCIS, in general, if the petition is, whether you're filing an H-1B CAP petition, a transfer, any sort of H-1B petition, the employer has to indicate on the petition that we file with USCIS the wage that the employer will pay. And it's not just any wage that you can select. Instead, the wage is it's determined in part by Department of Labor. The employer has to pay either the prevailing wage or the actual wage. The prevailing wage is the wage level that is set by Department of Labor. And that depends on the SOC code, the Standard Occupational Code, and it depends on the geographic location. So in other words, there's a different set of wages for every occupation or SOC code, and for every geographic location, also called the area of intended employment. So it's not as if Department of Labor sets one wage for all accountants, for example, in the United States, or one set of wage levels. It varies. The wage level varies depending on whether you're working in Richmond, Virginia, or in San Diego, California, or in Seattle, Washington, DC, wherever it is. There's a different wage level that is dictated supposedly by the cost of living. It's affected by the cost of living in that particular area. Hello to everybody who is saying hi. By the way, if you're only seeing my eyes, I apologize. I have a vertical setting set up on my system here. I will get rid of it. I couldn't quite figure it out before I needed to go live here, but I'll figure it out how to get rid of it. Otherwise, if you're seeing it, enjoy my eyes and the content. So the wage level is, like I said, set by geographic location. When I say the prevailing wage, like I said, that is set by the Department of Labor. For every SOC code in geographic location, there is a set of wages. When I say set of wages, there are 4 wage levels. Wage level 1 in general is for entry level positions. Wage level 4 is for the most experienced individuals in that, or professionals in that particular occupation, and wage levels 2 and 3 are in between. Department of Labor has a system to help employers figure out what the wage level should be depending on the particular there's a system to figure it out, depending on the particular SOC code, the particular occupation, how much education is required for the position, experience, any specific requirements, things like that. So it's not just a free-for-all, there's a specific way that we can figure this out. So like I said, 4 different wage levels for every occupation and geographic area. Okay. So that's the prevailing wage. The actual wage is what the employer is paying similarly situated employees. And the requirement in the H-1B realm is that the employer pay the H-1B beneficiary the higher of the actual wage or the prevailing wage. For the H-1B registration system previously, so this is what's changing with the weighted system. Previously, when we registered a person and a company for an H-1B to be entered into the lottery, we would only enter the basic information about the company and basic information about the individual beneficiary. So when I say basic information about the beneficiary, the person who needs the H-1B status, I mean things like their full name, their date of birth, passport information, that type of thing, and whether they were subject to the master's degree quota or to the regular quota. We did not enter information like the area of intended employment, where they will work, what their wage will be, what their job title and the SOC code will be. None of that was required for the registration. That will be required going forward because the selection, the H-1B lottery selection, will be based on the wage level. So the regulation says that if an individual is entered as a wage level 4, so in other words, we're going to have to put in, again, we don't have the system yet, but we're going to have to somehow enter where the person is going to work and their wage level, whether it's wage level 1, 2, 3, or 4, we're going to have to determine that ahead of time and enter that into the system. If a individual person who's registered for the H-1B lottery is entered as a wage level 4, they will be entered, they will have 4 entries into the lottery system. If it's a wage level 3, they'll have 3 entries. Wage level 2 is 2 entries. Wage level 1 is 1 entry. So in other words, there is a higher chance of being selected the higher your wage level is. So we've gotten several emails from existing clients and people who are looking for help with this saying, oh, I hear there's a requirement for the wages this year. Yes, there's always been a requirement for the wages for the H-1B. It's just that we're having to figure out what the wage is going to be, and then look at the wage level information from Department of Labor for the registration process now, rather than once we file the H-1B petition. And in our practice, that's something that we've looked at generally. What we want to make sure that the employer is willing to pay whatever the required wage is. We've looked at that, but we have not had to have that specific information and that really clear strategy mapped out for the registration previously. So we do have to have that now for this registration period that's coming up in March 2026. So again, it'll be based on wage level. Wage level 4 has the highest number of entries. Wage level 1 has 1, 2, 3 has 3, 2 has 2. So again, we have limited information from Department of Labor as how to that will be implemented. Hopefully we'll have more information soon. The other potential big change for this particular H-1B cap season, and when I say cap, I'm referring to the lottery, the numerical cap, the limit on the number of new H-1Bs. But the other potential change is not necessarily to the registration process, but rather to if you are selected in the H-1B process, there's the question of, does the employer have to pay the $100,000 fee? And again, I want to say it, number one takeaway here is the $100,000 fee only applies in limited circumstances. And we should be able to tell you ahead of time whether it's likely to apply to you or not. So once you engage our services. So the $100,000 fee, generally speaking, this is high level, applies if a person is outside of the United States and is not currently in the United States. So if you're currently in the United States, there are other exceptions as well, but if you're currently in the United States in a valid visa classification maintaining status, so for example, if you're here on F1, working on OPT, or potentially even CPT, or if you're here on an H4, L2, whatever it is, if you're here in the United States in valid immigration status, maintaining valid status, and if we file to request a change of status, if you're selected in the lottery. So this does not apply to the registration system. It only applies once you're selected. So once you're selected, if we request a change of status from whatever your current status is to H-1B, and if that change of status request is approved, the $100,000 fee does not apply. You could even work in H-1B status, and then down the road, you want to travel, go have the H-1B visa stamped in your passport and come back in, then the $100,000 fee would not apply. It only applies if an individual is outside of the United States seeking H-1B status. It can also apply in other circumstances. So for example, if you are in the United States and you apply for a change of status, and that change of status request is denied, either because you traveled while the change of status request was in process, was pending with USCIS, or because USCIS found that you did not maintain status, then your petition could be approved for consular processing, and then the $100,000 fee would apply. But in general, if you're here in the US maintaining status, it would not apply. So those are the two things that are potentially changing. When I say potentially, I just mean the $100,000 fee could apply in certain situations, but it is in place. You know, if you meet the requirements and it's you have to pay the $100,000 fee. It is here. It's not a proposed rule. It is actually here. The other change, like I said, the weighted selection also is here. It's coming. We just have limited information so far. So what's not changing with the H-1Bs? First of all, H-1Bs are still a thing. You absolutely can still apply for an H-1B petition. You can still register in the H-1B lottery, just like in previous years. We anticipate that the registration process will be similar. There will be more work required for us as the immigration law professionals, you know, as the immigration lawyers and the employer. There'll be a little bit more work on the front end, or more work actually on the front end, to make sure that we have really nailed down the strategy for the occupational code, the standard occupational code, the wage level, work site location, all of that, so that we can make sure that your wage level is optimized. Optimized meaning, you know, ideally higher, but also one that the employer can pay. So there's a lot of strategy that goes into that will have to be done before the registration is complete. So as I said a few minutes ago, we have several people asking, great question, what are the wage requirements? And it's not that that's a new requirement, it's that we're having to figure that out now, you know, before we actually submit the registration entry, rather than waiting until the H-1B petition is actually submitted. So what's not changing is the registration system itself. Like I said, it is changing, and that there'll be some additional details required, but the H-1B is the whole program is very much still here. Petitions are still being approved, and that's not going away. So the option for the H-1B is very much still here. The process of submitting the H-1B petition, once the case is actually selected in the H-1B lottery, will, as far as we know right now, will be the same. We will submit the petition between April 1st and June 30th. And if it's approved, your H-1B status will become effective on October 1st, or whenever it's approved. So what to expect going forward? These are significant changes. They are not, even though they're only a couple as of right now, they are not insignificant changes. So how can we prepare going forward? Number one, Sumner Immigration Law, I am having a webinar on January 27th at noon Eastern. There is a link to sign up for that webinar on our website. I'll put the link in the comments here as well so that you can sign up for it. It is a free webinar. It will be recorded. We will send the webinar to individuals that register for the webinar. So if you are an HR professional involved in H-1B registration, or if you are for a national individual for a national and you are wanting your employer to sponsor you for the H-1B, absolutely sign up for this. Hopefully we'll have more information about what the actual registration system looks like by then. Maybe, maybe not, TBD, but we will have a webinar, whether we have that information or not. We will have that webinar so that we can answer your questions in detail. There'll be a time to submit your questions ahead of time, and during the webinar to ask me questions as well. So first is register for the webinar. Second, if you are an HR professional and you know that you need to register one or more people, set a time to talk to us. Contact us. Our information will be on the outro slide. So set a time to contact us. If you are a current client, let us know. You know, we'll recognize your name, of course, but if you're a current client, we will be sending information on getting that process started probably by the end of January, or at least by the beginning of February. If you are not a current client and you're looking for an immigration lawyer to help you, we are happy to help. We are in the growth mode in terms of onboarding clients. We have capacity for additional clients. And the first step is to set a time for a consultation. Again, there will be information on the outro slide about how to set that consultation. Consultation can be set by the employer or by the employee. Ideally, both parties would be there so that everybody's on the same page. If you're a current client, start getting your list together. Even if you're not a current client, if you are an HR professional, start getting your list together of individuals that need to be registered in the H-1B lottery. It's really helpful to have, you don't need it immediately, but it will be helpful to have the job title, the job description, the proposed salary, and the worksite location, because that's all information that we will need to determine what the wage level will be for a specific person. If you are a foreign national and you know that you would like to be registered in the H-1B lottery this year, and I recommend that you register as early and as often as you can. So even if you have another 2 years left on STEM OPT, I still would register this year if at all possible. Anyway, if you're an individual employee, first of all, start having that conversation with your employer about what the H-1B process, registration process looks like. If you need an attorney, some employers have attorneys that they work with all the time. Others say, I don't know, who do you want to work with, and give some leeway to the employee. So if you need help, whether you are an employer or an individual employee and you have an employer looking to register you for the H-1B lottery, we are happy to help. And first thing to do is, like I said, register for the webinar on January 27th and set a time for a consultation so we can talk to you in more detail and come up with a strategy for you. My name is Emily Sumner with Sumner Immigration Law. If you found this video helpful, please share it with a friend or a coworker. Make sure you're subscribed to this channel so you don't miss our next video, and turn those notifications on so you don't miss our next video. I would love for you to like or comment on this video. I can't give legal advice, of course, in this forum, but I'm happy to answer general questions. My name is Emily Sumner from Sumner Immigration Law. We serve clients from around the United States and around the world with employment-based and family-based immigration matters. Look forward to seeing you next Tuesday at noon for our next Live at Lunch. Until next time.